And yes, I think that what she's done has violated his rights, has gone around the way the system is supposed to work. If she wants to have a platform to speak her mind, she can open up her own website, call it whatever she wants, as long as it doesn't infringe on his trademark. And she did exactly the opposite. She tried to buy his trademark. It's easy. You just go on a website, you pay a fee. You bought his trademark. Haha. Look what I did. And then after the fact, she must have looked into it and realized that's not how trademarks work. So for our next story here, if you remember, a few weeks ago, someone named John Edwards, the proprietor of Wedge Live, I think we showed this picture, or at least this thumbnail. John Edwards from Wedge Live announced to the world that he was being harassed. How do you even call it? A political opponent, or rather someone who is a political person who is sort of a personal opponent of his. He criticizes her, Carol Becker. John Edwards is more of a reporter. Carol Becker is the political person, is the politician. And John Edwards has a website or Facebook page called Wedge Live, where he writes things about his immediate, like literally local residential area called the Wedge. And she filed a trademark registration on his name, Wedge Live, for some reason. He's only been critical of her. And so she's filed a trademark registration on his name. Now, he filed a lawsuit and she withdrew her trademark registration, but now she has countersued in the lawsuit. And we, of course, have that counterclaim.
And I have to give a shout out to Tony Webster, who is another local reporter who was able to get this for me. Because as people remember from the Murray case, as soon as you start getting into state level or local level courts, it's much harder to get these documents. So shout out to him.
Thank you very much. Defendant Carol Becker answers plaintiff's complaint, states and alleges as followed. You know, let me at least give a shout out, because I always complain about the flourishing language in that first paragraph that takes up half a page, where everyone's like, comes now defendant by and through their attorney under the laws of the great Commonwealth of Confuciusville. And this one's nice and short. I'm impressed. We'll see if I continue to be impressed. I'm skeptical. Try not to be too biased, but I'm skeptical. Except as hereinafter admitted, qualified, or answered, defendant Carol Becker denies each and every allegation. Great. So if you're not familiar with how an answer works, there's not going to be a whole lot in the answer. Most of the answer from here on out is going to be deny, 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 deny. But that's not what we're here to see. Let me page through this, and we'll get to it. So more denials, admits certain allegations, and we could put this side by side with the complaint and go through part by part and see what she admitted and what she didn't, but I'm not thinking that that's the most interesting part of this. Then she goes into affirmative defenses. This is still not quite it, but these affirmative defenses are what you do to say, even if the plaintiff's allegations are true, I'm still innocent because of these things here. So very briefly, the complaint fails to state a claim upon which relief can be granted. That's a complicated way of saying that the law doesn't recognize the claim or the damage or the cause of injury to the plaintiff, and that somehow, you wouldn't be able to complete a claim on these facts. 82, plaintiff has failed to mitigate damages. You have a duty to mitigate your own damages. The best analogy I can use is if you hire somebody to fix your roof, but they don't fix your roof and a rainstorm comes along, are you allowed to just leave your roof completely unprotected and the rainstorm's coming, it's been on the news for 5 days, big rainstorm, did you get a tarp, did you hire another roofer, you do have a duty to try and mitigate the damage. So you might have a claim against the roofer who didn't show up, but you don't have a claim for the unmitigated damage that occurred because you just left his negligence to rot, to cause further damage. So if it's your house or your car or whatever, if they didn't fix it properly, you can certainly make a claim about that, but you do have a duty to then fix it first. So fix it from there. I'll give another example. Let's say you get your car fixed and you had a transmission problem before, and now you still have a transmission problem. Well, let's say they don't call you back and they don't return your phone call, they don't get your emails. The shop is closed when you go there, or they refuse you service or something. Well, you might have a claim against them for not fixing your transmission properly. But if you don't get the transmission fixed at another shop, and let's assume for the purpose of the hypothetical that you could afford it, if you don't get the transmission fixed somewhere and it goes and it grinds up the transmission and the drivetrain, and now that parts of the engine have to be replaced and parts of the frame and it totals the car or something, well, you probably don't have a claim for all of that because you should have gotten the car fixed even though the other place did a shoddy job. That's what that means. 83, plaintiff's damage were caused by his own action or conduct. 84, plaintiff's claims are barred by waiver or estoppel. Those are ones where like you've either waived a right or waived a claim, or you are legally stopped from doing something because of said actions or waiver of some kind. 85 is the most appropriate one, I think, trying to claim that his plaintiff's claims about the trademark are barred because the trademark has been withdrawn. Well, that's not quite how that works. I'll get to that in a moment. 86, plaintiff's declaratory judgment claims are barred because there is no controversy. Again, not going to quite be the way she says that. Then doctrine of unclean hands and in pari delicto is more like the plaintiff did something wrong and therefore doesn't deserve to have a remedy at law and under these facts. And then something about Minnesota common law and Minnesota civil procedure. So I've been keeping you on the edge of your seat, though. Her new allegation is that she withdrew the certificate of assumed name from the Minnesota Secretary of State on August 13th, that she requested abandonment with the USPTO on August 12th, that plaintiff authored an online post which he referenced to Becker being behind an effort to file business and trademarks registrations for Wedge Live on August 13th, that City Pages published an article in which plaintiff quoted, he could fight Becker in court if she tried snagging it again. Plaintiff initiated the lawsuit even though she hasn't tried snagging it again. Plaintiff is aware that she has no intention of ever snagging it again. Okay, I'll get to it. After initiating the litigation, plaintiff acknowledged that he is pursuing this litigation to guard against individuals and entities other than Becker. He authored an online post on August 23rd in which he says, I believe this or something similar is likely to happen again. If it's not Carol Becker, it will be someone with similar aims. I have begun a legal process. While I will continue to make jokes about this ridiculous situation, I'm also taking my position very seriously. I will do everything in my power to defend myself. I will not leave myself vulnerable, etc. I'm starting a fund, and then he has a GoFundMe. The Star Tribune published an article regarding the dispute, etc. So she alleges abuse of process, that he is using the litigation to assert some sort of frivolous litigation for some ulterior purpose, and that she deserves some kind of remuneration, monetary damages, taxable costs and disbursements, and any and all further relief that the court deems just and equitable. Except that's not how it works. That's not how any of this works. She does not have a claim against him for abusive process because he filed a lawsuit. That's not how that works. It would have to be an abusive, frivolous lawsuit that was filed for an ulterior motive. She's not wrong that those are the elements of it. But he still has a claim. And I'm not sure why she doesn't realize this. Maybe she hasn't consulted an attorney. It looks like there's an attorney listed here, Steingart and McGrath. Maybe this is just the best that they can do. But in my humble opinion, this is not good enough. A case or controversy does not become moot simply because one party withdraws their offensive conduct. It is true that a fight over that conduct may now be closed, and new conduct might be under a new claim, but that has nothing to do with abusive process. The Carol Becker situation does not moot anything that she withdrew the claim. All it does is close off further damages. So he does have a duty to mitigate damages. From here on out, he can't continue to behave as if she has an active trademark against him. He can definitely behave as if he's not sure if she's going to file one again, no matter how much she says she isn't. So he's allowed to get a adjudication on the merits of his existing claim. I still think he has a 1983 claim that she has acted under the color of state law and that it has violated his civil rights. I'm assuming that that'll be tied into this somehow, or maybe not. You don't have to do what I say, and certainly not legal advice either. I don't have enough information. Maybe there's a reason they don't want to go to 1983. Maybe they think they can do enough here with this, and that's easy enough for something. It's a different court system too, so who knows? But he has every right to get a declaratory judgment and try to prevent this from happening again, no matter how much she says it's not going to happen again. She was crazy enough to do it once. He should be given some kind of judgment, plus attorney's fees and costs and such, for her behavior. And her going on the offensive is interesting, but I don't think it's going to be very effective. But that's just my humble opinion.
Also, for the record, a few weeks ago, I did reach out to her and asked if she had a statement and if she wanted to comment, because at one point she had said that she would refile in 6 months. And so I asked her if she was still planning on doing that. I did not receive a response back.
Okay, and that makes it sort of worse if she at one point said that she's going to refile, and then even if she later said no, I'm not going to, that just shows her equivocation even more. That doesn't show that she's not that it disposes of the matter anyway, but it doesn't show that she's really thinking about not filing it. It shows that she's trying to decide a legal strategy. It doesn't show remorse and understanding. It shows legal strategy. So we'll keep following that and retweet that, and we'll do more videos on it as it unfolds. Because that's just so weird. Why would you go and make a claim to someone's name because you didn't like what they had to say about you? Go buy a couple keywords on Google. Write your own freaking article, buy a couple keywords on Google, pay a couple $100 to get your thing blasted out on PR Web or one of those other PR newswire services, and then let chips fall where they may. Jeez. Everybody's got to win by cheating in some way. And yes, I think that what she's done has violated his rights, has gone around the way the system is supposed to work. If she wants to have a platform to speak her mind, she can open up her own website, call it whatever she wants, as long as it doesn't infringe on his trademark. And she did exactly the opposite. She tried to buy his trademark. It's easy. You just go on a website, you pay a fee. You bought his trademark. Haha. Look what I did. And then after the fact, she must have looked into it and realized that's not how trademarks work. That's my paraphrasing of my understanding of it.
Yeah, it's pretty accurate. She admits in the first half that she knew about his blog beforehand, that she was aware that he was actively using the name Wedge Live, and she admits that she applied for the trademark even though he was already using the trademark.
And Wedge Live is Minneapolis, and someone just asked about anti-slap. Minnesota, excuse me. So Minnesota anti-slap. Minnesota's anti-slap lawsuit has perished at the Supreme Court. So no, Minnesota does not have an anti-slap law right now, according to this article. But yeah, her counterclaim would actually be something that would fall under an anti-slap law. The counterclaim is the same thing as filing her own lawsuit. It just happens to be able to be done for free, no additional court costs, I mean, within this lawsuit. So if it's true, according to Minnesota lawyer here, that the anti-slap law perished at the Supreme Court, it was 23 years old, the statute suffered from constitutional infirmity that violated plaintiffs' protected right to a jury trial. Okay. So they could have just simply re-implemented it then with the right to the jury trial. So I don't know. We'll see what the status is of that. But if they do have an anti-slap law, yes, this counterclaim probably falls under that. Wedge Live, John Edwards can probably add that as a new claim in their original claim, or make a motion to strike the counterclaim as in violation of the anti-slap law. I'm thinking claiming damages is probably the better one, so not striking it, but rather counterclaiming, counterclaiming the counterclaim. I don't know how that even works. Do you call it the counterclaim, or do you just call it a new amended claim? I don't know. All right, everyone, thank you for joining me. I am Leonard French, your favorite copyright attorney. This is the Lawful Masses Sunday Show, a community-supported channel and show that we do here. Thank you very much for supporting us on patreon.com/ljfrench. And of course, also the Twitch subscribers cannot be overlooked. Thank you very much for your support on Twitch. Not the least of which is Breakfast Demon. Thank you very much for your donation of 25,000 bits about 2 days ago. Thank you to Whiskers is Cat for your 1,500 bit donation, and thank you to Faily 2008 for your 500 bit donation. Really appreciate you all there. Thank you to the Patreon sponsors. At the $50 level, we have Jonathan Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Grunkle Tia Marie, Terry Crisp, Richard Fournier, I think I got it right, and Michael Jones. Thank you very much for your support, and thank you to the $5 plus supporters who will be scrolling on the crawl, and as well as the LED panel behind me. I have some dog video for you to take us out. Thank you.
Here's fried chicken. His method is interesting. He always seems to want to go on the first step and then jump from there.
He's very careful. He's very gentle. The exact opposite of Ilsa.
Kind of wonder what would happen if they had a child.
Which is a little tough right now.
A little tough, since she's been spayed and he's been neutered.
Listen, I have a mouthful of water. My ears are probably full of water. And you want me to hold on to this?
Come on.
What time do you have to be
The
back?
ride's over with. Come on. I'm out.
Glenn, what time do you have to be back home?